Roughly a fifth of the world's oil passes through the Strait of Hormuz. At its narrowest point, the waterway is only 21 miles wide, flanked on one side by Iran and on the other by Oman. Iran's closure of the strait has sent energy markets into crisis and forced the ceasefire negotiations to confront a question that goes far beyond bilateral diplomacy. Who controls one of the most strategically vital waterways on Earth? And what does international law actually say about it? The legal framework governing international straits is clear in principle, even if it is contested in practice. Under the law of the sea, straits used for international navigation are subject to the right of transit passage, a principle codified in the 1982 UN Convention on the Law of the Sea, or UNCLOS, and widely regarded as reflecting customary international law. This means that ships of all states, commercial and military, may pass through freely and continuously. Coastal states may regulate navigation for safety and environmental reasons, but they cannot suspend transit passage and they cannot charge for it. The foundations of this principle run deeper than UNCLOS. The Corfu Channel case, decided by the International Court of Justice in 1949, established that states have no right in peacetime to obstruct innocent passage through straits used for international navigation, a narrower but older right on which transit passage was built. Neither the United States nor Iran is a party to UNCLOS, but both are bound by these rules to the extent that they reflect customary international law, a position the US accepts and Iran contests, insisting that only innocent passage applies. The ceasefire MOU signed between the United States and Iran creates further tension with these principles. Under paragraph 5, Iran undertakes to ensure safe passage of commercial vessels through the strait, charge-free for 60 days only. The phrase "for 60 days only" is legally significant. It implies that after that period, different arrangements may apply. But under what is widely regarded as customary international law, transit passage through an international strait cannot be made conditional or time-limited by a coastal state. The MOU also envisages Iran conducting dialogue with Oman to define the future administration of the strait, in consultation with other Persian Gulf coastline states. A bilateral or regional arrangement of this kind is not inherently unlawful, but it faces a hard legal constraint. It cannot restrict the rights of third states to navigate freely. The Strait of Hormuz is not Iran's or Oman's to administer as they see fit. Its legal status belongs to a body of international law that governs all maritime passage. There is also the question of mines laid by Iran in the strait during the conflict. Customary international law, reflected in the 1907 Hague Convention on Submarine Mines, requires these mines to be cleared after hostilities end, and the MOU sets a 30-day deadline for doing so. Whether that timeline is realistic and who bears legal responsibility if commercial vessels are damaged before clearance is complete remains unresolved. The MOU has reopened the waterway. Whether it has resolved the legal questions surrounding it is a different matter entirely.